Hello and welcome everyone for the CLAT lecture series for the preparation of CLAT examination. In this particular lecture series, we are in detail discussing the legal reasoning portion of your CLAT syllabus, in which a CLAT aspirant is expected to know the basics of the law so that once the question will be asked in your legal reasoning portion of your CLAT examination, the student is able to be well versed with the principles and then analyze the situation and then answer the correct answer. In this particular lecture series, we have been discussing the important areas of the law and the legislations. We have discussed the Indian Contract Act. We have talked about the criminal laws. We have also discussed the Constitution of India along with the law of torts. And since past few lectures, we have been discussing about the family law. When you talk about CLAT examinations as such, the areas which is being covered by family law, it entails over the sources of family law, the marriage, divorce, inheritance and succession. So all these are important topics which are going to be asked in your CLAT examinations as such. And we are trying to understand all the important principles through this lecture series. We have so far completed the sources of the Hindu law as well as the Muslim law. And in our past video, we have started with the Hindu Marriage Act. In this particular legislation, we are talking about the rules and regulations that are important when you talk about having a valid Hindu marriage. When you talk about a valid Hindu marriage, we are talking about marriages that is solemnized or consummated between two Hindus. And what exactly is a Hindu has already been studied and already been discussed in our previous lecture. In this particular lecture, we are going to discuss what are the conditions for a valid Hindu marriage and what are the requisites one needs to fulfill in order to make sure that the marriage is a valid marriage. As we have already discussed in our past video, that there are three kinds of marriage that entails whenever we are discussing the validity of the marriage. The first and the foremost is a valid marriage, which will obviously be having all the essentials and all the conditions fulfilled. And if the marriage is solemnized according to the conditions that has been laid out by the legislations, then that marriage will be considered to be a valid marriage. If certain conditions which can be changed or which can be altered and which can be covered up, and those conditions are not fulfilled, then that marriage will be considered to be voidable marriage. That means that marriage is valid in the eyes of law until unless it is questioned that these conditions were not fulfilled, and that is why we need that particular marriage to be considered to be a void marriage. Now, what is void marriage here? Void marriage means that marriage which has not been able to fulfill the conditions of the Hindu marriage, and that is why that marriage has been considered as a void ab initio, meaning which that marriage never existed at the very first place. So that is why it becomes very important for any Hindu whenever he is going to get married, and if he falls within the domain and jurisdiction of the Hindu Marriage Act of 1955, it is an important requisite to understand that what are the important conditions that one should fulfill in order to make sure that he is having a valid marriage. And that is why in this particular lecture series, we have started with the Hindu Marriage Act. We have already completed the first four important sections which talks about the definitions that are going to be handy whenever we're going to discuss the whole legislations. We have discussed about the short titles. We have discussed what exactly is a Hindu, which we discussed about the different sect of the society like the Lingaya, the Shivayas, who are considered to be Hindus. And we have also talked about Jains, Buddhists, who are also considered as Hindus, and those society which are not considered as Hindu. We have also discussed that is Muslim, Christians, Parsis and Jews. So Hindu Marriage Act in total, if you talk about in a wider perspective, it is governing almost every sect of the society, excluding the Christians, the Muslims, the Parsis and the Jews. Now in this particularly, we are going to discuss the conditions of Hindu marriage, which will ensure that if these conditions are fulfilled, then the marriage is a valid marriage. So as you can, if you are able to see the screen, I suppose you are able to see the screen. We have discussed in our past lectures. Let me see if it is working or not. Yes. So we have what we have discussed. I'll just like to give you a quick revision so that we can start with the lectures as of now. We have discussed the date and the amendment. When the legislation was created, we talked about that it will be applicable among the Hindus, and it was on the 6th year of the Republic of India that it became applicable. We discussed the title's name and what exactly is the Hindu domicile, and when it will be applicable. It will also be applicable to people who are domiciled outside India, but they have been the resident, and they have been the national or the nation of India, Indian citizens itself. So the Hindu domiciled in the territory to which the act extends, who are outside the said territories, are also applicable by this act. Then we have discussed that to whom this act will be applicable. We have discussed about the Buddhist Jains, and we have discussed that it shall not be applicable to Muslim, Christians, Parsis and Jews. And then we have discussed about the legitimacy of a child and illegitimate child, when they will be considered as a Hindu or not. In the same way, we have talked about the converts and the reconverts that also will be considered to be the Hindu. And then we have talked about the scheduled caste and the scheduled tribes, which has been mentioned under the Article 366 of the Constitution, which we mentioned that until unless by the official notification of the central government, if the tribes that has been mentioned under the Articles 366 of the Constitution, they will not be considered as Hindus until by notification the central government declares otherwise. Then we have discussed about the expression Hindu. It will be considered that it will include a person who is not a Hindu by religion, if nevertheless a person to whom act applies by virtue of the provisions contained in the sections. So there are some exceptions to it. That is also we are going to discuss. But for a CLAT perspective, that is perhaps not more important, because this is not more important. The reason being, this is actually something that you will be discussing and understanding in your college durations. So we have completed the definition portions. We have talked about the important the provisions and the definitions that we have talked about. The definitions of customs, what exactly is customs. We have talked about what exactly is a district court. We have talked about the full blood, half blood, which is an important portion for your CLAT examination. We have talked about the uterine blood. And then we have talked about what exactly is prescribed, what is spender relationship. We have discussed about the 3 sectors of on the mother's side, and 5 areas of ancestrals in the father's side, and how if anybody is related from this particular line of ascent with this a person who is considered to be the first generation, then that marriage cannot be held, or it cannot take place, because they are among the spender relationship. And if they are spinders in line of ascent, then they are not supposed to get married. Degree of prohibited relations, if they are said to be under the prohibited degree of relationship, meaning which they are falling within the subinders. And if this is the important portion that we have already talked, that if there is some relations like this, then you are not supposed to get married to that person, because that marriage will not be considered to be a valid marriage. In the same way, we have talked about the overriding effect of this act, which means that if there is anything which is being mentioned in other legislation which is contradicting to this particular act of Hindu Marriage Act of 1955, then perhaps this act will be considered, and the act which is in conflict with the present act of Hindu Marriage Act will not be taken into consideration. So meaning which this act is providing you all the important essentials and requirements and the conditions that needs to be fulfilled when you talk about the marriages within the Hindu domain or the Hindu marriage. Okay. So now we are going to talk about the conditions. This is perhaps a very important portion and the most sought after when you talk about Hindu marriages for your CLAT examinations, that what exactly are the conditions that needs to be fulfilled, and apart from that, after the conditions, what exactly are the ceremonies that needs to be fulfilled, and then the important provisions we obviously will be taking forward after discussing the conditions of the Hindu marriage. So let's start. Let's see what exactly this particular section says. It says that a marriage may be solemnized between any 2 Hindus if the following conditions are fulfilled. So first and foremost thing, that what is the need between 2 Hindus and how will it be solemnized? So the first condition is neither party has a spouse living at the time of the marriage. Since in Hindu religion, we only allow monogamy. So since only monogamy is allowed, it means that if there is any spouse can be either husband or wife. So let's take an example. There is a one person X. He has a husband. She has a husband living, and she wants to get married again to another person. This type of, if she marries within the time period when the husband is alive, then this marriage is considered to be void ab initio, because since the husband is alive, she is not supposed to get married. Neither party has a spouse living at the time of the marriage. Okay, so if at all, what happens is, why is it important to understand is because often we have seen through our experience in the past that people tend to get married to a person, and then after a certain period of time they come to know that they have already had a spouse living when they were married. So the marriage with whom that person has married, for example, this is person X, okay, and he is not married. So he has the authority and the right to marry any person Y or Z according to his wills and choices. Condition is neither Y should have anybody as husband or wife, neither Z should have any husband or wife. Okay, so if it is a female, obviously she will not have a husband, and if it is a male, then that will not have a wife. And then if this particular X is a person who wants to get married to X or Y, then obviously we'll have to make sure that there is no husband or wife present, meaning which the person should be a bachelor, he should be single, and then only he is supposed to get married, and then only that marriage will be considered to be a valid one. So the first condition is that neither party has a spouse. Has a spouse means has a husband or a wife living during the tenure of the marriage. This is the first thing. At the time of the marriage, neither party is incapable. Neither party is incapable of giving a valid consent to it in consequences of unsoundness of mind. So the first and the foremost thing here, what we need to study is what is a valid consent. Valid consent means a consent that we have studied during our lectures of Indian Contract Act. The same valid consent follows that it should not be by force, fraud, misrepresentation, mistake, undue influence, etc. So we have already studied what exactly is force, what is fraud, what is coercion. Okay, what is coercion, what is misrepresentation, what is mistake, what is undue influence. And if any of these things are present, then it will not be considered to be a valid consent. And if a person is of unsound mind, then obviously he is incapable. He is incapable of giving a valid consent. So that is why that consent will not be considered to be a valid one, since the person is unsound. So that marriage will also be not considered to be a valid marriage. And the question comes up here. That type of marriage, if a person who is incapable of getting married, he marries, then whether that marriage will be considered as a valid marriage, void marriage, or voidable marriage. So the questions that will be put up in front of you will be exactly in this manner, that there will be a situation that will be put in front of you, and then there will be asked that whether that person marriage can be considered to be a valid marriage, void marriage, and voidable marriage. In this particular condition, if you can see, is incapable of giving consent to it in consequence of unsoundness of mind. So meaning which, the person who is sane, okay. So the condition is there is one person X and there is one person Y, okay. So let's take example that X being a male, he's a male and he is sane. Y on the other side is insane. Now what happens is that both of them decides to get married. X knows this point that Y is insane, okay, and X knows this point, and then nevertheless they get married. Okay. Now the point is whether this marriage is considered to be a valid marriage, void marriage, or voidable marriage. The answer is this marriage will still be considered as voidable marriage. I suppose the screen is not working. Is it frozen? Yes, now it's working. So it will consider to be a voidable marriage on the instance of Y. On the instance of Y, and it will be considered to be a valid marriage on the instance of X. The reason being, X knew the very fact that Y is incapable of giving the consent, and even after that, he married Y. So X now cannot go and to the court and say that since she was incapable of giving her consent, this marriage is considered to be a void marriage. It will still be considered as a voidable marriage or the instance of Y, and valid marriage for the instance of X. The reason is Y, once she comes to know that she has been married, if at all she is now not insane and now she's sound, and she comes to know that this marriage is a marriage which I was not supposed to marry the person X, but because of unsoundness of mind I have married. So the marriage will be considered to be voidable for her, meaning which if she feels like that yes, she wants to continue with this marriage, she can continue and the marriage will be considered to be a valid marriage. But if she willingly wants to not continue with marriage, then she can approach to the court and she can tell the court that see, I was not able to give my valid consent, and the marriage that took place was not according to my sane consent. So I don't want this marriage to be continued, and that's why I want divorce. So that the marriage will be considered void and the person will be separated. But if X wants to go to the court and then say after a certain period of time that she was insane, she is insane and I don't wish to continue with this marriage, so we will see to it that at the time of marriage, whether X had this knowledge or not that the person Y to whom he is going to get married is a sane person or insane person. Okay, so if the person is insane and still you're getting married, then it is something that you by yourself is giving a consent, valid consent that yes, I wish to marry this person, and then that marriage will be considered to be a valid marriage on behalf of X. But when you talk about Y, since she's not able to get married, she's not able to give a valid consent, that marriage will be considered to be voidable marriage on the instance of Y. So whenever we are going to discuss about marriages as such, we need to see that for whose condition we are talking about. If we are talking about marriage which is about a person who is X, who has been considered to be a sane person, then according for him, it will still be considered to be a valid marriage, and for a person who is incapable of giving the consent, it will be considered as a voidable marriage. So I suppose the concepts are clear to you, and with this we will move forward and we'll discuss about the important areas which is also important when you talk about the conditions of marriage. The second is, though capable of giving valid consent, okay, has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children. So I've just informed you that the person has been given a valid consent. Okay, she has given a valid consent, but it comes to the knowledge that mental disorder of such a kind and extent as to be unfit for marriage and procreation of child, then this marriage will be considered to be a void marriage. Void marriage if she is of mental disorder of such a kind that she is unfit for marriage and the procreation of children. Okay, has been subject to recurring attacks of insanity. So if she has been subjected to recurrent attacks of insanity, then the person shall be considered the marriage as void marriage. In the previous example, when we were talking about incapable of giving a valid consent and the consequences of unsoundness of mind, and we talked about Mr. X who knew this fact. But the problem is sometimes what happens is that the other person, Y, their family, their relatives never disclose that Y is unsound. And then the marriages takes place. Here for X also, it will be a void marriage because he was under the impression that the person is not unsound but rather sound. So this type of information is being provided, it will not be disclosed. Had that been the situation that X knew that Y is insane and still they decided to get married, then it will be valid for X and voidable for Y. But if X was not knowing that Y is insane, then this marriage will be considered to be void ab initio. Understood? Means it will be considered to a void marriage. In the second instance, if it comes to the knowledge that the person is unfit for marriage because of the procreation of children, then that marriage will be considered to be a void marriage. Has been subjected to recurring attacks of insanity. If that thing is also not known, then that marriage will also be considered to be a void marriage. Another condition that needs to be fulfilled when you talk about marriages, that the bridegroom has completed the age of 21 years and the bride. Here, bridegroom means the male and bride means female. So for male, the age is 21 years and for female, it is 18 years. And this is applicable prospectively. Now, what is prospectively? That after the creation of this legislation, Hindu Marriage Act of 1955, only people who, when you talk about male is of 21 years of age and female of 18 years of age, then only they are supposed to get married. If they are married before that, then that marriage will not be considered to be a valid marriage. It will be considered to be a void marriage. The parties are not within the degrees of prohibited degree of relationship. That is, I've already informed you. Unless the custom or usage. Now, this is important for you. Unless the custom or usage governing each of them permits of a marriage between the two. So if you have a custom where which you are allowed to get married, I'm so sorry. Even if you are allowed to get married according to your customs within the sapindas, meaning which the prohibited degrees, which is talking about the 3 lines of ascent for the females and 5 lines of ascent for the male. If the customs and usage of your society or your community allows it or permits it, then the marriage can be solemnized. So this is an exception and it is an important portion. If there is a question that is complicated, then you have to take into consideration this particular condition also, that prohibited degree of relationship does not allow marriages between prohibited degree. But if customs or usage in that particular society allows it, then marriage can be solemnized. meaning which it is not essential, it is not compulsory that under the prohibited degree of relationship you cannot marry. You can marry, but the only requisite is that your customer usage should allow it. So from all the condition, it is very much clear that there is only one way or one condition, meaning which if this particular condition, we talk about the third condition about the male of 21 years of age and female of 18 years of age, all the type of marriages can be either voidable or valid if the conditions are fulfilled, or it will be considered as void. But if the three things can be made possible, if the conditions are fulfilled, then valid. If the conditions are fulfilled but the knowledge from one party is obviously insane, then it is voidable on the part of the other party. And if there is no free consent, then the marriage will be considered as void. But if the condition third, that the bridegroom is of 21 years of age, is not 21 years of age or less than that, and the female is lesser than 18 years of age, then the marriage will mandatorily be considered to be a void marriage. So it becomes a very important question that will be put up in front of you in your CLAT examination, that out of those conditions, which condition specifically tells you that if this condition is not being fulfilled, then the marriage will be considered to be a void marriage. So you need to remember it, that this is the third condition which talks about the age, which if not fulfilled, the marriage by default be considered to be a void marriage. The parties are not subpoenas of each other, that we have already submitted, unless the customs are allowed. So this is we have already understood in our previous conditions. So making which that if we summarize that what are the conditions that is required when you talk about the Hindu Marriage Act, the first is neither party has spouse living. Okay. So in this particular condition also, until unless the person is not, there is no disclosure that the other party has a spouse living, it still be considered to be a valid marriage. Once it comes to the knowledge that their spouse is living, it will directly be converted into a void marriage. Second condition is about unsoundness of mind. So unsoundness of mind, I've just explained it to you, that if it is a valid consent which has been given by the party who knows to this fact that the person is insane and still wants to get married, then the marriage is a valid marriage. But it will be considered to be voidable at the instance of the party who has been insane, because he is not able to give his free consent. So the crux is that first we need to understand that what exactly is the crux. Crux is the consent. The consent should be free. Now, in this particular scenario, when you talk about neither party is a spouse living, it means that the person, if their consent has been given, knowing to this fact that the person has a living spouse and they have still married, then that marriage will not be considered to be a valid marriage. Reason being, in Hindus, we don't allow polygamy. So that marriage by default be considered to be a void marriage. So this condition number 1, and condition number 3, which talks about the age, that is 21 years for male and 18 years for female. These two conditions, if not fulfilled, it will directly convert the marriage to be a void marriage. And apart from this, if any other condition is not being fulfilled, the marriage will be considered to be a voidable marriage. So we need to understand that which condition, if not fulfilled, the marriage by default be converted to void marriage, and which condition, if being fulfilled, the marriage will be considered to be a voidable marriage. This is something that we'll be going to study in our upcoming lectures also when we talk about void marriages. See, that has been mentioned also here. If so declared, any marriage solemnized after the commencement of the act shall be null and void, and may, on petition presented by either party, any of the parties against the order, be so declared by a degree of nullity if it contravenes with any of the sections which are in clauses 1, 4 and 5 of the SATHEE Act. Which any marriage solemnized whether before or after the commencement of this act shall be voidable and may be annulled by a degree of nullity if the following early, that the marriage has not been consummated. First thing is the marriage is in contravention to the condition specified in clause 2. I just explained to you clause 2. It is talking about that sense only. Okay. This is the consent of the petitioner. The petitioner under section 5 is stood immediately of that. That is not important for you. And that the respondent was at the time of the marriage pregnant by some other person other than the petitioner. So this also is a condition where which the marriage will be considered to be a void marriage. Notwithstanding any condition in subsection 1, no petition for annulling the marriage on the ground specified in clause C of subsection 1 shall be entertained if the petition is presented. Now that is something that is not more for you for understanding. So we have discussed about all the important conditions that needs to be fulfilled. When you talk about the condition 1, this is if this is true, that the marriage will be considered to be a void one. At the time of marriage, this will be considered to be a void one. Okay. And then the third condition, this by default will be considered to a void one. The fourth condition, if not by prohibited degree of relationship, then it will be considered to be void. But if the customs allow, then that marriage will be considered to be a valid marriage. Okay. And then the subpendas are not, unless this will be considered to be avoidable if they are going to marry. So these are the conditions that are important when you talk about CLAT, when you talk about the Hindu Marriage Act. What are the conditions that needs to be fulfilled? The guardianship has been repealed, so you need not discuss. Now, in the upcoming lectures, we'll be talking about the ceremonies of Hindu marriage. What are the exact ceremonies that needs to be fulfilled? We are talking about the sacred fires, that is known as the Saptapadi. And apart from that, we'll be discussing about the registration of marriages. And then we'll see through it that what exactly is restitution of conjugal rights and judicial separation. Then we'll talk about the void marriages, voidable marriages, and what exactly is divorce. After completion of the divorce, we will be moving forward and we will be talking about divorce by mutual consent. Then what exactly is this clause saying that no petition for divorce be presented within that? Does that mean that for 1 year you cannot file for divorce? The answer is no, it's not like that. No, it's not true. You can still file for divorce, but it is the duty of the court to make sure that when they are providing the degree of divorce, it should 1 year has completed. Okay, so this can be done, and this is something that we're going to study also. Divorced persons when may marry again. So this is something once they get the degree, then they can marry. Legitimacy of the child, that is going to be studied also. What is the punishment of bigamy? If you have already been married and you act in such a way that you are single and you get married, then it is attracting a convention, or rather a penal section of 494 and 495, which is talking about bigamy, which is a punishable offense according to the Indian Penal Code. Okay, so these are the things that we're going to study in our upcoming lectures. So I suppose you're very much under the provisions of the Hindu Marriage Act, the conditions that needs to be fulfilled when you talk about the Hindu marriage has been understood. They are the 5 requisites that needs to be fulfilled. We need to understand that which type of clause is talking about void marriage, when it is going to be avoidable, and when it is going to be a valid one. So we will be again continuing, and we will be discussing it in detail when we talk about the void marriages, voidable marriages, and valid marriages. That if these conditions are not being fulfilled, then that marriage will be considered to be a valid marriage, or void marriage, or voidable marriage. I suppose the concept is clear to you. We will again be meeting you, and we will be discussing the further sections in our upcoming videos. Till then, I would again request you all to be consistent with your practice for your preparation of your CLAT examination, and you make sure that you are consistently revising what are all the concepts that we are studying so far, and then you are analyzing and applying those concepts in your practice papers. Do remember that we have to follow the three basic P's, which we have talked about in our earlier lectures also, and right now also I'm going to explain it to you, that the practice, the principles, and the persistency is the key to clear the CLAT examination. With this, I would like to thank you all for being present in this lecture series, and we wish you the very best of luck for your preparation. Let's meet in the next video where we will be going to discuss the further sections of the Hindu Marriage Act 1955. Thank you so much, guys. Bye-bye. Take care.